I'm going to discuss two claims against you in respect of Tony against Birmingham Ballet Company as well as Maria against Birmingham Ballet Company. There are four elements to a claim in the tort of negligence: actionable damage, a duty of care, a breach of that duty, and causation, both factual and legal. I'll advise that you, Birmingham Ballet Company, are likely to hold liability in each claim. The first claim is based upon the injury to Tony's eye which he has suffered whilst at work, under your supervision. To give you the best advice, it is necessary to determine if there is actionable damage in the claim. Indeed, Tony has suffered eye damage from the stage not being swept. This is potential negligence. Under Section 38, subsection 1 of the Limitations Act 1980, a personal injury includes any disease and any impairment of a person's physical or mental condition. Therefore, Tony has suffered an actionable damage through the stone hitting his eye. It must be questioned as to whether you owe a duty of care towards Tony. The principle of the duty of care was established by Donoghue against Stevenson. Lord Atkin refers to your neighbour-in-law. The fact that you are Tony's employer and he is your employee holds great weight. There is an employer and employee relationship. However, your failure to sweep the stage could be an admission as a failure to act. However, the general rule is that there is no duty of care in an omissions case. Further, Lord Gough said in Smith against Littlewoods that the common law doesn't impose liability for what are called pure omissions, similarly shadowed by Lord Hoffman in Stoven against Wise. Nonetheless, this differs with special relationships, such as employer to an employee, as where there exists a special relationship between the parties, there is a legal duty to act. Therefore, you did have a duty of care towards Tony. The responsibility held towards Tony needs to be looked into to see whether you breached that duty of care. This is an approach that academic Joseph Ross supports. In the case of Rothwell, Lord Hoffman outlines that symptomless illnesses do not result in a cause of action in negligence, as you have to be in a worse off position than you were before. Therefore, the case of Rothwell outlines that you need a proof of damage, not just physical change. You need to be in a position where you are worse off than before. In order to examine whether you have breached your duty of care towards Tony, the reasonable test will be used. In the case of Blythe against Birmingham Water Company, Alison discusses that the negligence is the omission to something which a reasonable man would do. Indeed, in the healthcare at home case, Lord Reid outlines what is meant by a reasonable person. Your inability to clear the stage could be outlined as a breaching that duty of care, as a reasonable person could foresee that damage would occur with stones on the stage. It is likely that a breach of duty to care will be established here. However, in order for Tony's claim to be successful against you, he will have to identify that your breach of duty is what has caused the damage that he has suffered. This is where the actions of the hospital become involved, where we begin to question whether the actions of Dr. Riff would break the chain of causation. In order to know this, we have to establish whether the hospital's treatment made a difference with Tony's blindness, or whether he was going to go blind regardless of the initial injury. We must look at the factual causation of this claim. This uses a but-for test originating from the Barnett case to establish that the loss they have suffered was caused by the defendant. In regards to the but-for the defendant's actions, would the claimant have suffered the loss? If yes, the defendant is not liable. The action by Dr. Riff is related to that of the original injury, meaning that it is not a supervening act, a novus actus intervenius. Therefore, but for the negligent act, Tony wouldn't have had to have the surgery which has resulted in him going blind. This test looks at balancing the probabilities if something is more likely than not. You would need it to weigh in your favour in terms of the balance of probabilities, as it is an all or nothing system. If you contribute more than 50% towards the damage, then full liability can be established. Indeed, but for the negligent act, Tony would not have needed surgery or the eye drops. To fit the criteria of legal causation, the harm must not be too remote, and it has to be reasonably foreseeable. In this claim, I believe that the damage from the initial injury is not too remote, as it is reasonably foreseeable that the damage would occur should they not clean the stage after the repair. We don't know whether Dr. Riff explained the potential risk to Tony regarding the eye drops, which could be influential. Nonetheless, it could be argued that the eye drops made Tony's medical condition worse, as they were only experimental methods of treatment. In reality, it is unlikely that the court would give liability to the medical professional that carried out the surgery, especially since it wasn't carried out negligently. Legal causation could still be found, meaning you will be responsible for the harm. If the courts do not find you liable for the harm to Tony, there are possible defences you could use. Under the Law Reform Contributory Negligence Act, the defence of the contributory negligence would account for the doctor's intervening act of giving the eye drops after the surgery. However, this defence would be unlikely to succeed since Tony acted on the medical advice of Dr. Riff. You are therefore likely to be liable for Tony's damage. The other claim we must look at is the claim brought against you by Maria for the exposure to asbestos. Again, under the Limitations Act, this damage is actionable as she has suffered skin damage. We must look as to whether there is a duty of care owed to you by you to Maria. For this, we would have to use the Caparo test since it is not a pocket of case law. In this case, Lord Bridge outlines that the neighbourhood principle. Although Maria is not an employee, she can still argue that you have a duty of care towards her. Your failure to deal with the asbestos has caused danger. This is something that you should take care to deal with so that your employees or members of their family are not exposed to asbestos. The Caparo test requires three things. There must be reasonably foreseeable that Maria was at a reasonable risk of the harm. Maria will argue that you knew of this potentially foreseeable risk. She will also state that, but for the exposure to asbestos, she would not have suffered this condition. Although it would have affected Bernardo's clothes, it is reasonably foreseeable that after touching his clothes, it has transferred. The case of Maguire should be discussed as the facts of the case are very similar. However, the court said that a reasonable person could not foresee this, and therefore, in this case, Maria may struggle to claim this. There has to be proximity between the parties. However, there has been criticism with this as there is not a clear definition of proximity, and not every moral obligation involves a legal duty. For proximity, the claimant doesn't have to be present at the time of the accident, as found in the case of Taylor. It also has to be fair, just and reasonable to impose a duty. However, it has been said that it is not a practical test. Indeed, Lord Reed in Robinson said that you can't apply Caparo, but instead adopt an approach based on precedent, with case law developing incrementally. However, you may not have been aware of the risk of asbestos, so you did not know that you needed to take these steps in order to stop the exposure of this risk. Indeed, you will be liable for the damages, as there was asbestos found in the piping, which would have passed on to Bernardo. Therefore, under Section 3 of the Compensation Act, you will be liable. However, the Mesothelioma Act 2014 now allows individuals who have no one to sue for the claim of damage from asbestos payment from a compensation fund paid for by the insurance industry. Nonetheless, there is no way of knowing if it was the dust from the Birmingham Ballet Company that caused the damage by the asbestos. It may have also had contribution from the London Ballet Club. There is no possible intervening act for this claim. This means that we cannot use the but-for test in this case, as it is impossible to tell if 51% or more of the damage was caused by you, Birmingham Ballet Company. Therefore, instead, we would consider Lord Bingham's Fairchild Principle. The House of Lords held that where a claimant could satisfy the burden of proof that one employer had materially contributed to their asbestos exposure, the claimant could claim total compensation from them. There are conditions to this, such as the evidentiary gap and that the defendant materially increases the risk of the harm. It would be impossible to say if the asbestos came from just you or just the London Ballet Company, or both. However, there is a strong policy argument in favour of compensating those who have suffered grave harm. However, this brings rise to the joint and several liability between Birmingham Ballet Company and London Ballet Company. This means that you could claim contribution from the London Ballet Company, as outlined in the Barker case. In this case, the Fairchild Principle was applicable as the claimant could prove that the defendant's tortious negligence had materially increased the risk of injury, and so they were entitled to remedy. Therefore, you are likely to be liable to an extent for both claims.